Hi everybody, this is T.A. Srinivas, General Counsel, welcoming you all to the second part of the patents and Indian business concerning filing patent, infringement and remedies available to business. Filing a patent involves the following steps. First of all, we have to determine the type of patent. We have to decide whether to file for a provisional or a non-provisional patent. Then it may be necessary to conduct a patent search. We need to do a research of existing patents to ensure that your invention is novel. Determining patentability, we need to assess whether the invention meets the patentability criteria. May be necessary to prepare a provisional patent application to establish an yearly filing date. Prepare and file a non-provisional patent application within 12 months of the provisional patent application filing date. Submit the required documents including specifications, drawings and claims with your NPA. Pay filing fees. It may be necessary to pay the filing fees and make this application or processing. After filing, wait for the patent office to review your application, and it may also be necessary to respond to the issues or objections, if any, raised by the patent office. Then comes the receiving the patent. If approved, receive a patent that grants exclusive rights for a specified period. Some of the additional tips for consideration by business houses includes: consider hiring a patent attorney of good standing to help with the process. Maintain detailed records of your invention and filing process. If necessary, file internationally. If desired, file for patents in other countries within 12 months of your initial filing date. The patent filing processes and requirements may vary depending on the country and its jurisdiction. To check for patent infringement, businesses can follow these steps. What are these steps? These are essential because conduct a patent search. Research the existing patents available in the industry or the technological area. Identify relevant patents and focus on the patents that closely match your products or services or processes. Analyze and study the claims section of the relevant patents to understand what is protected. Compare your products, services or processes with the patent claims. Assess the likelihood of infringement based on your comparison. If unsure, as mentioned, consult with the able patent attorney of a standing for his professional opinion. Continuously monitor competitors and industry developments to stay informed about potential infringement risks. Conduct a thorough clearance searches before launching new products or services. Perform a freedom to operate analysis to ensure your products or services do not infringe on the existing patents. Development an infringement response plan to address potential infringement allegations or lawsuits may be another good strategy. By following the above steps, the steps which we discussed, businesses can proactively identify and mitigate patent infringement risks, minimizing potential legal and financial consequences. In India, the patent infringement occurs when a person manufactures or produces a patented product or process without the owner's permission, employs or utilizes a patented product or process without the permission, offers for sale, sells or distributes a patented product or process without permission of the owner, imports and brings into India a patented product or process without the permission of the owner, advertises or offers a patented product or process for sale without permission of the owner. Infringement can be either a direct infringement, directly using or making a patented product or process, indirect infringement, inducing or contributing to infringement by another party. Literal infringement refers to infringing the exact claims of the patent. Infringement under the doctrine of equivalence, infringing the essence or spirit of the patent claims. Infringement can even occur if the infringer is unaware of the patent, the infringer makes minor modifications to the patented product or the process, the infringer uses the patented product or processes for different purposes. To determine infringement, the Indian courts considers various factors like patent claims and specifications, 2. Infringing product or process, 3. Expert testimony, prior art and existing knowledge. If infringement is found, the patent owner can seek both civil as well as criminal remedies. The civil remedies for patent infringements include 1. The damages, the monetary compensation for past infringements, including loss of profits, royalties, and even other expenses. Injunctions, a court order making, using, or selling the infringing product or process can be obtained by the owner. Accounting of profits, the infringer of a patent may be required to account for and pay over the profits from the infringement. Reasonable royalties, the infringer may be required to pay reasonable royalty rate for each infringing product or process. Lost profits, the patent owner may be entitled to lost profits resulting from the infringement by the infringer. Price erosion damages, this refers to damages for reducing the market price of the patented product. The other one is a convoyed goods damages, damages for infringements of a patent related to a component of a larger product. Cost and expenses, reimbursement of cost and expenses related to the litigation may be paid for and it may be granted by the court. Declaratory relief, a court declaration that a patent is valid and infringe. Mandatory licensing, in some cases the court may even order the infringer to obtain a license to continue using the patented technology of the owner. In India, criminal remedies for patent infringements are outlined in the Patents Act 1970 and the Bharatiya Nyaya Sanhita BNS supports this. These remedies include imprisonment up to 3 years. This is provided under Section 20 of the Patents Act. Fine up to 1 lakh. This is contained in Section 120 of the Patents Act. Seizure and destruction of infringing goods. Confiscation and destruction of infringing products is provided for under Section 108 of the Patents Act. Forfeiture of equipments and materials. Seizure of equipment and materials used to create infringing products can be asked for under Section 108 of the Patents Act. Restitution, compensation to the patent owner for losses suffered due to infringement. This is supported by Section 106 of the Patents Act. Cognizable offense, patent infringement is a cognizable offense allowing police to arrest without a warrant. This is a very beautiful, excellent remedy. This is provided at Section 120 of the Patents Act. The courts may also impose additional penalties such as cost and expenses. The court may order reimbursement of costs and expenses related to the litigation. Mandatory licensing, as discussed, in some cases the courts may order the infringer to obtain a license to continue using the patented technology. Criminal proceedings for patent infringements in India are typically initiated by the patent owner filing a complaint with the police or the court. The authorities will then investigate and prosecute the case. Criminal penalties for patent infringement in India are relatively rare and usually reserved for extreme cases. Civil remedies are more commonly pursued. These remedies aim to compensate the patent owner for past infringement and prevent future infringement too. The specific remedies available may vary depending on the jurisdiction and the facts of the case. Thus, a true owner of a patent is being protected under the patents law. Ladies and gentlemen, I have written a book by name Product Launch 360 Degree. This small book captures the challenges faced in the launching of a product or services by any business houses. This particular book will be useful for those people, especially industrialists, business owners, and B school students who would like to know the challenges and mitigate such challenges in launching the product. I recommend everyone to go through this book and enlighten themselves. Thank you so much for your kind listening.